picked
Maybe
out
a
of who
couple
wasn't gonna
things
help.
on it, yeah.
Strategic Planning Committee for November 14, 2019 is called to order. Everyone is here, and if you don't mind, Mr. Randy Cluett, do the invocation, please.
Everyone, please stand. In the name of the Father, Son, Holy Spirit. Dear Lord, we thank you for this day. Lord, we ask that you continue to take the citizens of the parish through the cold weather, the winter coming. We ask that everyone look side to side, look to your neighbors, the elderly, and those that need help. Lord, it's with a special prayer that we ask that you look upon the victims and the families of the shooting in the California school today. We ask that you continue to try to spread peace, and give people some way to resolve their differences beyond violence. We ask this in the name of your Son, Jesus Christ. Amen.
Amen.
All right. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, there's no chair's addition. Public comment period, if you have anybody want public comment period, shine the red or the green card. Item number 5, approval of September the 12th, 2019 strategic planning minutes.
Motion.
Motion by Mr. Cagalani, second by Mr. Doc Sadler. All right, motion, no objection, motion passed. Okay, item number 6, approval of proposed ordinance to amend Chapter 13 of Occupation License, Taxes, and Regulations to the Article 8, Disadvantaged Business Enterprise of the Sanction Parish Code of Ordinance.
Motion. Second.
Got a motion by Doc, second by Mr. Todd. Any objection to or question?
Question.
Question, yes, Mr. Cluett.
Mr. Parrington, can you explain to us what this is?
It would be a program where you would establish disadvantaged business, where they would be, where the council by ordinance would set a percentage that on parish projects.
Right.
Parish contracts, that you would set aside for disadvantaged businesses, and those would have to be authorized disadvantaged businesses. They'd have to meet the criteria to do such.
Thank you. I just wanted everybody to understand, I want to know that this, let everybody know that this happens in other entities and on other state levels and federal levels. Depends on where the money's coming from. Thank you very much.
Mr. Cagalani.
And also, you know, we with Oliver's intense work that he's done on this, we're going to be a projects in the opportunity zone. It's going to open up some doors for us, and this further, you know, advances that we're going to be, you know, giving disadvantaged business enterprises an opportunity as well. So it's all good.
Right, and the only comment I have to say, but it's also gonna look good for points and credits and everything for road projects and stuff like that. So, without that, no one else have any question, no objection? Motion approved. All right. Oh, Neil, I got one question. This here go to the council for,
Introduction of an
intro-
ordinance.
Okay.
All right, but I think we need to fill in who's gonna do what before we do that. But, you know, there was some, what the percentages were and things like that, we need to talk about that and have that, at least have that resolved in the ordinance.
Well, the ordinance, in that ordinance, we have a provision in there that they can set their goal within a year.
Okay, that's fine.
That's right.
Okay,
So they said, if anybody got any other question, I have Mr. Cedric Grant out there that is,
Let him come to the podium.
Mr. Cedric, since they asked a question on that point system.
Good to see you
percent-
again, Cedric.
Mr. Clark, very good to see you. Mr. Parrington was out, so I took the liberty of filling in some of the blanks for him. Basically, what we've done here is that it's the intent of the parish to set this goal within a year. Because there's an elaborate goal-setting process that needs to occur. So we'll go through that. And the intent here to get this program started is to use the registry that currently exists in the Department of Transportation and LED, which gives you about 1,300 businesses to start with that have already been certified and met all these criteria. And so we can begin to do some of this work. Basically, After that is the administrative process of managing it. In the example that Mr. Parrington gave me, I put the chief administrative officer has to promulgate rules to provide for the management and oversight of this program, including submitting a budget and annual reports to you on meeting that goal.
It's just that in Cedric, I know you could expand for about an hour on
Yes,
this.
sir.
With both of our professional histories, but I mean, I've done state projects with state and federal funding, and I've done federal projects. And this is not going to cripple any project in
No,
any
sir.
such manner.
Not a
And,
bit.
Thank you.
All right, thank you. All right. Motion was approved and it'll move forward. All right. Going to item number 7, discussing proposed amendment, amend the Home Rule Charter, Section 8-18 to limit Ascension Planning Commission authorization to approve, deny, subdivide primary flats. Doc Sadler.
Thank you, Mr. Chairman. Historically, back in October of 2018, I started the issue that's before us this evening, gentlemen, as you probably well know, through this committee back when I was the chair. There was some discussion that maybe it couldn't even be done. That precipitated a Attorney General's opinion, which I think, I'm not sure if it's in our package this time, it was when we heard this issue at the last Strategic Planning Committee meeting. And that's Attorney General Opinion number 18-0175. Without going into great depth of that opinion per se, I would like to, as I did last time, highlight 2 sentences that are, in my opinion, indicative that we can proceed in the manner in which I have proposed. Referencing number 1, an earlier opinion, the current Attorney General's opinion 18-0175 referenced opinion 03-0110 with the proposition that, and I will quote the Attorney General opinion, powers granted to the Planning Commission are those set by state law, and here's a key word, I'd like to bold it, italicize it, underline it, unless and until the charter is amended to provide otherwise. To me, that's indicative that the Attorney General is saying, no, you can't do what we're proposing here unless the charter says you can do so. So it would require a vote of the people to amend our current homeroom charter. The Attorney General, in opinion 18-0175 before us this evening, rendered for the parish of Ascension Parish, went on to state, and I'm going to quote again, quote, it should therefore be clear that the powers of the Planning Commission may not be lessened, and there's the word again, except, like to bold, italicize, and underline that word, except by an amendment to the charter adopted by the voters of Ascension Parish, unquote. So with that, Mr. Chairman, it is my desire, and I'll go ahead and make it, a motion that we forward this matter to the full council with legal, adopting necessary legal language for eventual placement of this issue onto a ballot so that the citizens of Ascension Parish can decide if that's what they want to do. And I thank everyone for listening.
All right, Doc. Doc have a motion, but if anyone, Jerome, I know we did ask Doc, we asked Jerome to do a list of all parishes on that. I know Jerome did that. Jerome, you don't mind speaking on
No, I
what you
don't.
found out on that?
I don't mind
Point
at
of
all.
order, Mr. Chairman, is there a second to my motion? Maybe we don't even
Well,
need to hear any
that's-
testimony. If
I
no one wants to
asked
do this,
There's
or
anyone
even hear
second?
discussion, a second just means we have discussion.
No second at the present time, so we can go straight to discussion on this item, and maybe you may get a second, Doc.
I'll be happy to talk about this.
All right.
When I prefaced my remarks when this first came up, my first order of business was to contact my friend at UNO who teaches in the urban planning program there and asked if they've done any research on this in the state. And his response was no, but this is going to make a great master's project for some student out there. So with that said, we don't have any research. So what I did was have my staff and I went through this, and this, I wanted to thank Jamaica Baker on my staff for having done this. Any errors that appear here will be mine alone, but she did a really good job in compiling this information. What you see before you on this chart is all the parishes that have a home rule charter, as well as a council president type of government. There are other parishes that have home rule charters like Terrebonne, East Baton Rouge, New Orleans, which is another animal altogether, that don't have council president type of government, so I kind of left them off the chart, all right? But as you see on here, the first column is the parish name, obviously. The
Mr.
second
Yeah,
one,
can you shrink that a little bit?
Yeah, so the people can see it at home.
Yeah,
I'm sorry, yeah.
The other way.
The other up.
all right, come back.
There we go.
Yeah,
First column states whether they have a planning commission, right? So we have two on the list that do not. Jefferson Parish has what's called a council, an appeals, not an appeals board, but an advisory council, or an advisory commission. And they advise information to the parish council, and the parish council takes ultimate action. The other that does not have a planning commission is Plaquemine Parish, right? The third column here asks whether the preliminary plat is approved at the planning commission level. And as you can see, Ascension, yes; Iberville, yes; Jefferson, no. Again, whatever commission they have, the planning commission or planning advisory board they basically take advisory action, and that action is submitted to the parish council, and the parish council has the ultimate approval of the preliminary plats, right? Livingston Parish is the same. Livingston Parish, for your information, also does not have a zoning ordinance, right? So that's of interest to us as well. Plaquemine Parish and St. John the Baptist and St. Landry Parish, and also St. Mary Parish and Washington Parish, and then again West Baton Rouge Parish. All of those preliminary plats go to the parish council for ultimate approval, right? So again, that's in their charter, and that's the way they operate, all right? So again, the fourth column says preliminary plat advisory, and it's just basically the opposite of whether they approve it or not. And then the council approval is, for the preliminary plats, is either yes or no, and you can see that on the chart. So it varies by area. Ascension and St. Tammany Parish are the only two parishes where the council actually approves the preliminary plats, but the planning commission approves the preliminary plats, but the council acts as the appeals board, right? So you, as a parish council, due to recent action, are acting as the appeals board for any denial of a preliminary plat at the planning commission stage, right? So with that, I'm open to questions, right? So.
I got,
Question, any?
I got a quick question, and maybe, I'm gonna ask it of Doc, is what are you trying to accomplish here? So, and what's the basis of this move?
Okay, thank you, Randy, for asking that question, and like a follow-up, Mr. Chairman, if you will, while I have the floor to.
Go ahead, Doc, you got the, Randy gave it to you.
Well, to answer also something that Jerome said, both of the individuals. Referencing Randy's question, the issue, well, let's just talk first about zoning. Zoning in our parishes, we know, with the zoning commission, and for the reference of the people playing at home, we have actually two commissions, a zoning commission, which is separate from a planning commission, even though we call it the Planning and Zoning Commission. They're two separate commissions. And currently, the zoning commission, of course, makes recommendations. Let's say if someone comes in and wants to change their property from medium residential to a mixed-use category, mixed-use 2, a mixed-use 3, or whatever, that's solely a recommendation to the council. Then it comes on our agenda, correct me if I'm wrong, Mr. Fournier, and then we say, we uphold their decision, whatever their recommendation is to approve or deny, or we have the discretionary authority to reverse that decision. On the other hand, planning decisions, as Mr. Jerome has put in here on PC plat approval, or as he said, that's column 3, PC plat advisory, the reciprocal of the same. In other words, if you have a yes in the third column, it's going to be a no in the fourth, or if you have a no in the third column, it's going to be yes in the fourth column. I was actually kind of surprised and I'm very impressed. And thank you, Jerome, for the work. It looks like about 19 or 20 parishes were studied, and about half of them do their PC plat approval process like their zoning commissions, which is a recommendation to the council for final disposition, which means in the fourth column, the planning commission plat authority is advisory and not final. So what I seek to do is to copy of the 20 parishes studied here. Looks like 10 are doing what I'd like to see us do. The other 10 are not, which would be status quo if no one wants to back this issue. That we be making then our planning commission, like our zoning commission, advisory in nature, which would mean that they would we wouldn't do the vetting, they would still do all the vetting and the work, but when one would come forward, just like a zoning decision, it would come to the council, then the council would say yay or nay to whatever their recommendation would be. I might also add that I think this is a better system, and last time, you might remember, or actually I don't think, Randy, you attended, but we had 5 public speakers. They're not here tonight. I'm not overly surprised because it's a cold, rainy night, but nonetheless, they all spoke in behalf of wanting to do this, because from the resident standpoint, and what I hear a lot on my website and otherwise, and people who contacted me about this, and they're pushing hard for it, is we would like to hold our elected representatives on the council for each of the 11 districts responsible for the final approval or denial of any new major or minor subdivision plat. As it works out right now, by appointing individuals to do this, and we wouldn't be taking the work away from them necessarily, doing the vetting in the system I'm proposing, as it exists, as I say, in about 10 other parishes from what Mr. Jerome has found out. But what would happen then is that, if the decision is not something that the public likes or would want it to have happened, then at the polls, they can hold the council responsible for that, versus the councilman could easily say, I didn't do it. These people that are appointed, and the only thing they have to say there is, well, you appointed them, but as we all know, no individual council member appoints them. It's a collective effort of all 11 district councilmen. So I hope that kind of answered it. And then the question to you, I kind of covered it answering Randy's question. Jerome, columns 3 and 4 then, correct me if I'm wrong, are indicative that about, of the 20 you studied, or 19, whatever it is here, about half of them, for the record, you actually named the ones that have a system that I'm seeking, like to see happen, and I think the people would like to see happen, where they would be advisory in nature, they meaning the planning commission, but final disposition, the responsibility and authority of the council, and then the other half are pretty much like we're doing right now, status quo. Is that not correct, sir?
That's correct. Yeah, there are 21 parishes listed on this chart, and 10 of those.
Couldn't get it
as you
any
said.
closer. And so I do agree, whoever made
Approximately half, yeah.
I will say this, Mr. Jerome, whoever made the comment, being an old college professor myself, everybody knows me as the old chicken doctor, this would be an excellent master's, if not doctoral, because if you expanded it to, all the comparisons and contrasts you could make with planning and zoning, and you started to look at issues of who's the appeals board or not, it looks like the pioneers of change right now looks to be St. Tammany and Ascension, and we actually did that recently under the what is that, 1, 2, 3, 4, 5, the 6th column of the data you had up there, council appeal. So we're quite different in that regard, and I think that was a very positive change, by the way.
Well, if I
so-
might comment on that?
Yeah,
Um,
absolutely.
In our research, when we've actually talked to numerous planning directors, a lot of parishes have looked to us for a lot of leadership in how we're doing that, and the appeals board was one of those, in fact. The council acting as the appeals board was certainly something that other parishes looked at very
Right.
closely.
And I would say this, I don't want to get too far off topic, but I guess I'm the guy that instigated it. when it comes to appeals, the way I see it, and the people that I represent say this all the time, once again, we want you making the final decision on that and not an appointed board. And in fact, in that particular case, our old homeroom charter, or law, I guess, said that the president appoints that board. And so the district councilman's electorate, so to speak, doesn't even, has some control of that, but only 1/11, if you want to look at it that way, than a direct responsibility for electing a councilman. But yeah, I think an MS or a PhD study here would be very interesting. I'd certainly like to read it. And thank everyone for listening.
Okay.
I have one,
Randy, you
I have
wanna
one
go
other, yeah, I'd like to floor back for a quick second. O'Neill,
Yes, sir.
so currently we have the, and if you've got this chart in front of you, the.
I got it.
The PC plat approval, okay, is, planning zoning commission, or planning commission, whatever one you want to call it. And just to make everybody clear at home is that if you come to one of those meetings, that they actually, Doc, correct me, you served on that they actually meet as a meeting for planning.
Right.
And then they actually meet as a meeting for zoning, being the same, committee members. So we've ran into some legal issues in the past.
I think this causes a legal issue.
Well,
In
I
fact,
just want to, I want to clear that up, and I want your opinion after that. We ran into some legal issues in the past on whether we can legally, and I'm gonna use the word not approve, but basically legally, it comes in front of you, once the Planning and Zoning Commission approves, and then it comes in front of us, and so just clear that up for me.
Okay.
We had a lot of conversation a good while back. Doc, thank you for bringing up October 2018, because that might have been when like 99% of that conversation had taken place, and I slept since then. Go
I
ahead,
did
sir.
some research on that, and Jefferson Parish has the advisory board. That's what they are, an advisory board. They're only advisory. They're the poster child for arbitrary and capricious. Because what happens is that board vets it, and then it comes to the council, and just like Councilman Sadler said, the people in the district don't want it. So Jefferson Parish said, fine, we'll vote and deny it. They were found arbitrary and capricious, had to pay the developers attorney's fees, and had to give them the permit. Now, there's been a big change in the law since then. In June of this year, the U.S. Supreme Court ruled out that you now have to, for the last 34 years, if someone was denied in a state matter, they had to exhaust their state remedies before they go to the state. Now, the U.S. Supreme Court has said, no, you can file a suit under the takings clause of the Constitution immediately in federal court. And that's a question of fact that goes to a jury of, not of the peers of Ascension Parish, it would be the entire middle district here. And if this is something that the council wants to do, I think they should at least wait till we get some feedback from the Supreme Court on what that actually means. I mean, the major case was a case out of Pennsylvania, where the only allegation was that placing hours of operation on a business was a taking of property. And the Supreme Court said, you don't have to exhaust your state court remedies anymore. You can come directly to the federal court. I think that this would be, if you want to write checks to developers, make it advisory.
Okay.
Because you're either going to pay their attorney's fees or pay them for takings
Yeah, I was just
claims.
wondering how working the other way, how that worked out for some of these
It
parishes.
has not worked out well.
And, we kinda like almost, go down to Plaquemine, Plaquemine's parish, and like I said, in
I looked at
Jefferson.
Jefferson more than anything because, I mean, you're saying some of these little parishes, they don't have anything going on, so you really have very little that goes on. And some of them don't have zoning, and if you don't have zoning, it always has to go to the council because you have to give them a use permit.
Thank you, sir.
All right. Hagelin, you got any questions? Todd? All right, Doc, we're gonna
Yeah,
go back to the second round, like you said.
I would, my response to what Mr. Parrington says, just said would be, as far as it being arbitrary or capricious when the council, let's say, decide differently from what the planning commission would be recommending, I think that same situation exists clearly right now for zoning. And to me, it would be more of a problem and bring a lawsuit that if, yes, they did it for an unreasonable, arbitrary, or capricious reason, versus they saw something maybe that the planning commission didn't see and were able to point it out and so forth and made that decision. I don't know how many lawsuits have been filed, if any, of all these 20 parishes, and especially well, not all 20 of them, I guess the 10 that have the precedent we talked about. Seems like we'd be jammed up in the courts with a bunch if that's not working.
We may be with the
Well,
Supreme
I
Court just
don't-
ruled in June, and
I
that's
don't-
what,
yeah.
nobody knows what's gonna happen there. That's the scariest thing of all.
I guess
because-
what I'm saying, I'd be willing to trust the discretion of the council. Some of the members of currently here that are gonna be reseated, and even the new ones that would come in to make a non-arbitrary, capricious, or unreasonable decision. In fact, that's what you're trusting from the get-go at the planning commission and zoning commission levels of these appointed people, who, quite frankly, may even have a lot less experience or training in doing so. But I think, we're liable, they're liable, everybody's liable at all time if they make an arbitrary, capricious, or unreasonable decision. And I would just hope that wouldn't happen. You'd make the decision for some really valid reason. Of course, we can get into a lot of problems there too, because there's the gray area, and we got an Attorney General's opinion on that. Well, even if all the codes are met, all the I's are dotted, all the T's are crossed, we have current commissioners, their attorneys who believe you've got to approve, and it's no discretionary authority. Attorneys' general opinion would indicate otherwise. We went through that too, and it states, I think rather clearly, that even if all those things are done, you can still deny a proposal if you believe in your heart of heart, and the burden of proof is extremely high. I've talked to lots of attorneys about this, that the health, safety, and welfare of the people are being jeopardized. So I'm not overly concerned with it, and, so I still back with what I started back in October, and I think it's a positive step for this parish that we would join the other 10 parishes that are currently doing it. And, if it wound up being a real burden, it's like anything else. You can certainly change the law back to the way it was or whatever, but I really don't anticipate that being the case. But I thank everyone again for listening.
Well, the problem with that is Nick versus Township of Pennsylvania says that upon the change of the law, that's a taking, if it's a taking, and you pay from that date.
Okay.
The
Mr.
Supreme Court has
Mayor.
not acted on, until you get some feedback from the Supreme Court on that, I don't recommend any vast changes in our land use laws.
So do you disagree, sir, with the Attorney General's opinion in front of us?
What? No, I agree that you can do it. I'm
Okay.
from a legal
You
standpoint, as
just
a
don't
legal
think it's-
advisor to the parish, I
You're
recommend you
saying
not do it.
we
at
have
this
the
point in
authority
time.
to do it, but you don't recommend it because you think it could be
I
problematic?
think that it's, right now especially, is very problematic because you have no clue what the Supreme Court's going to say on land use. They have said property rights are the same, should be treated the same as the right to free speech, the freedom of religion, the right to own the Second Amendment, all those. And the other thing that kind of makes me scary is the Fifth Circuit, which we're part of, the U.S. Fifth Circuit has said that states may have access to the immunity clause, the 11th Amendment. It was a Mississippi case, counties and municipalities are not. So any judgment in those cases against Ascension Parish would be seizable from the assets of the parish. It's not like a state court judgment where you can figure out ways not to pay. If you get a federal court judgment against you, they can seize it. They'll send a marshal down here to take the money from Ms. Gwen.
Okay, well, Mr. Kluat, I think we got our legal.
Okay, two quick comments. One, I want to reflect back and doing away with that appeals board. I was in favor of that, okay? Matter of fact, I felt sorry for the 3 or 4, whatever, I think it was 3 people that sat on that appeals board. I felt sorry for them, not getting paid for what they did and getting their butts whipped all the time. And so that was a different direction, that went in the right direction. And Jerome, I mean, I don't keep score, and I don't think you do, but as I'm sitting up here with 4 other fellow council members, and we're 5 out of 11, how many times that something comes here from the Planning and Zoning, and I'm gonna just say Planning and Zoning Commission, comes forward to us, and y'all have a recommendation connected with that,
Right.
and that we deny, or I'm gonna call it denying your recommendation, but basically, how many times do we disagree and go the other way?
Yeah, I don't think many.
I don't
but-
remember a lot,
Yeah.
okay,
But
at all.
let's remember, that as we're talking about tonight, those are all zoning decisions. Because the zoning matters, as Councilman
Doc said,
Satterley
yes.
said appropriately, is that all zoning matters go to you because you're changing the ordinance.
Right,
All right?
that is correct.
And that's the difference, because if it's a planning matter, if somebody's just wanting to develop their property under the existing ordinance, they're able
Yes.
to do that, that goes before the planning commission, and they have the right of denial or approval of that particular plan for that
Right.
process, you know? So, you know, as we talked about, and as Mr. Parrington said, you know, we have a zoning ordinance that's typically called the Euclidean zoning ordinance, and it's
Right.
based on a Supreme Court decision back in the 20s of Ambler Realty versus the town of Euclid, Ohio.
Yeah.
And that basically, the Supreme Court said that we can set up a zoning ordinance, all right?
Right.
And it basically said that all zoning ordinances are good.
That's
We
that's
had
the
a local
ordinance we're
state
trained on, the Euclid. That's the one we're
Euclidean
trained
zoning.
on.
And we also had a local, statewide Palermo case, which is based in I think it was in Calcasieu Parish, if I remember correctly, where they downzoned the property. And they sued that particular, local jurisdiction, and that was upheld at the local Supreme Court, the state Supreme Court level, all right? So we have some precedents for zoning matters, but when it comes to planning, as O'Neill said, you know, we're subject to this thing called arbitrary and capricious, and, you know, we need to be cautious about it. I'll just put it that way.
Well, I just want to say that I appreciate Doc's,
Mm-hmm.
you know, his opinion on all this, and that definitely, you know, and in some municipalities, in some governmental forms, that people want their elected official to be the final answer on everything.
Right.
But some things are set up to where it's more than just the elected official, that by the time something comes to us, you know, we feel like that there's some logical decision made that's being presented to us.
Mhm.
And so,
Another thing, I didn't expand on this, that was not part of the question, but, you know, somebody does do a master's thesis on this or a PhD level thesis, they can look at how planning commissioners are chosen and are appointed, you know? And some of the parishes we've seen, each council member has the ability to nominate somebody to be on
Right.
the planning commission. So you do it by district, as opposed to doing it just parish-wide, you know? So those are some options that are available to the parish, instead of just saying, let's abolish the whole, or not abolish, but remove the rights of them for planning approval.
well,
There you go. Yeah.
well, if I would be selfish, I would really want to say so in everything, and I would want to appoint all my own members from my district to the boards that represent
Right.
their people. I just don't have that option. I don't even know if that's a good ethical option.
Yeah, absolutely.
So, thank
Okay.
you, sir.
All right, Doc?
Yeah, just a final thought, as Jerry Springer would say. I find it fascinating, Jerome and everyone else, fellow committee members, O'Neill, all due respect, that if the Supreme Court believes all that you say they believe, and it's fixing to come down on us with the sword of Damocles beyond what we're doing, we currently have in all our system checks and balances. To wit, we have, of course, we just talked about the appeals board. And so if the board was still a president-appointed one as we had versus the one we've now embraced, being brazen enough to do that along with only one other parish in your survey, St. Tammany,
Yep.
it would seem to me then that, okay, let's say we stayed the old way, okay, and they overturned the decision made by the planning commission. How do you decide which one was arbitrary, capricious, or unreasonable? Now, the same could be said, now, if the council's doing that job, that we all say we're happy with, and we must be because we voted it into law, agreeing with St. Tammany, that, let's say we disagreed with the recommendation coming forward, do an appeal. Will we be an arbitrary, capricious, or unreasonable, or was it the first body? I just, ladies, gentlemen and lady, there's only one lady in the courtroom this evening, don't get it. And I thank you again for listening. I'm looking forward to my, frankly, personal retirement.
Good deal.
All right. Okay, so, Doc, you did make a motion, didn't get a second, we discussed it, and so, that is it for this item. We
Motion to
discuss-
adjourn.
Second.
Second. Meeting adjourned.